Welcome to the award-winning Consumer Finance Monitor podcast, where we explore important new developments in the world of consumer financial services and what they mean for your business, your customers, and the industry. This is a weekly podcast show brought to you by the Consumer Financial Services Group at the Ballard Spahr Law Firm, and I'm your host, Alan Kaplinski, the former practice group leader for 25 years and now senior counsel of the Consumer Financial Services Group at Ballard Spahr. And I'll be moderating today's program. For those of you who want even more information, either about the subject that we're going to be discussing today or anything else that involves the world of consumer financial services, don't forget to consult our blog, which also goes by the name of consumerfinancemonitor.com. We've hosted our blog since 2011 when the CFPB became operational, so there's a lot of relevant industry content there. We also regularly host webinars on subjects of interest to those in the industry, so to subscribe to our blog or to get on the list for our webinars, please visit us at ballardspahr.com. And if you like our podcast, please let us know about it. You can leave us a review on Apple Podcasts, YouTube, Spotify, or wherever you access your podcasts. Also, please let us know if you have any ideas for other topics that we should consider covering or speakers that we should consider as guests on our show. Let me also mention one other very important thing. We're very proud to report that a company called Million Podcasts, which is a podcast database service, has ranked our Consumer Finance Monitor podcast in the top 25 among hundreds of financial services podcasts nationally. The service recently published a list of the top 100 financial services podcasts. Consumer Finance Monitor also ranks as the top law firm podcast in the country among the top 100 financial services podcasts, as well as the only one focused on consumer financial services. So that we're very proud of that achievement and hope you don't mind us tooting our horn just a little bit. So let me tell you about our podcast show today. Going to first tell you about the subject, then I'm going to introduce our speaker, and then our speaker and I are going to engage in a discussion about this very important topic. So the topic we're going to be talking about is called the Unitary Executive Theory. And the name of it sounds rather abstract and unclear exactly what it means. And it really was not of that much importance during the last administration of President Biden, but has now really come to center stage under the administration of President Donald Trump. And let me tell you why. The wave of firings by Donald Trump targeting Democratic members of independent federal agencies can be clearly understood as a bold assertion of the Unitary Executive Theory, which is a constitutional philosophy that centers on expansive presidential control over the executive branch, including not only executive branch agencies, but so-called independent agencies. Here's how these dismissals fit into that framework. At its core, the Unitary Executive Theory holds that The U.S. Constitution vests all executive powers solely in the president. That's in Article 2, Section 1. Therefore, the president must have direct control over all federal officers who exercise executive authority. Congress cannot limit the president's power to direct or remove executive branch officials, even those serving in so-called independent agencies. This theory is often associated with conservative legal thinkers, including Justice Clarence Thomas, former Attorney General William Barr, and legal scholars aligned with the Federalist Society. Now, let's talk about the firings that embody the Unitary Executive Theory. Most of the officials that have been fired by Trump in the last couple of months, like National Labor Relations Board member Gwen Wilcox, FTC commissioners, and inspectors general, were statutorily protected. At least they thought they were. Congress specifically required that they only be removed for cause, such as neglect of duty or malfeasance in office. Trump's actions disregard those limitations, effectively asserting the president cannot remove any executive officer, that he can remove any executive officer at will, regardless of what Congress says. Many of these agencies, the Federal Trade Commission, NLRB, National Labor Relations Board, the CPSC, the PCLOB, were designed to be independent of political influence. By firing opposition party members or replacing leadership wholesale, Trump sought to eliminate political pluralism and bring agencies fully under presidential control, defying Supreme Court precedent, especially the 1935 opinion in Humphrey's Executor versus U.S. The Supreme Court ruled the president cannot fire commissioners of independent agencies at will. That precedent has been a cornerstone limiting executive power for nearly a century. President Trump's actions directly challenge that case, aiming to reverse or severely weaken it, consistent with the universal executive theory goal of eliminating judicial and legislative checks on executive removal. These firings appear designed not just to consolidate power, but to provoke legal challenges that might lead the current conservative Supreme Court to overrule Humphrey's Executor and fully embrace the unified executive theory. The court's May 2025 decision, which allowed Trump's firings of some members to stand, including the NLRB, hints at this ideological shift. So let me now introduce our speaker today, who is an expert on the Unitary Executive Theory, and his name is Pat Sobkowski. He teaches constitutional law, courts and public policy, and American politics at Marquette University. His scholarship focuses on constitutional and administrative law, specifically the administrative state and its relationship to the other branches of government. He's currently working on a book on the steel seizure case during the presidency of Harry Truman. So, Pat, a very warm welcome to you. Delighted to have you enlighten us today on this very important theory.
Thank you, Alan. It's a pleasure to be on the show. Thanks for having me.
Okay. So I gave, I guess, a very simplistic definition of the Unitary Executive Theory. Is there any more you want to add to that before we dig into the history of it and some of the details?
No, you did a really good job of covering it. I guess what I would like to draw attention to is, you referenced, just the name of the theory, the Unitary Executive Theory, right? At some level, it's very abstract. It sounds very much up in the clouds, a very, law professor type of term. But really, when you look into what proponents of the Unitary Executive say, it's what Cass Sunstein and Adrian Vermeule have called sort of a simplistic theory, right? It's this idea that the executive branch is very hierarchical. The president sits at the top, and below him or her is sort of a pyramid-like structure. Everything that happens in the executive branch and every government official or agency that exercises executive power has to be subject to the control and at some level direction of the president. So the term sounds kind of abstract, but when you look into what the argument for the unitary executive is, it's relatively simplistic, and we can talk more about that if you would like, but that's what I would add.
Yeah. Okay. Let's talk about the genesis of this theory. When and where did this theory originate?
That's a really good question. So there are competing interpretations. The proponents of the unitary executive, primarily, as I think you are correct to say, are right of center legal scholars and judges and politicians, up to and including presidents. Many of them would say that this is the vision of the executive branch and of the Constitution more in general that the framers of the Constitution had in mind, right? They'll point to quotes from Alexander Hamilton, from James Madison, so on and so forth, to sort of legitimate the unitary executive theory. What I think the better answer is in terms of where the unitary executive theory was born was really in the Reagan administration. The question of why is complicated. A really great political scientist, his name is John Dearborn, he teaches at Vanderbilt, just published an article, and his argument is that the unitary executive theory during the Reagan administration really became popular and important because of the Reagan administration's desire to sort of control and minimize civil rights enforcement at the federal level. I think that that's persuasive. It makes a lot of sense to me, but really the theory begins in the Reagan DOJ. You can see traces of this in the Nixon administration, this sort of rhetoric, particularly in Watergate, but really the unitary executive theory as a theory begins with the Reagan administration.
Okay. So I mentioned during my introductory remarks an important case called Humphrey's Executor, 1935 case. And that case, very simply involved the then president removing a member of the Federal Trade Commission without cause. And that was challenged, not by the commissioner was removed, he died. So it was the executor of his estate seeking back pay for the period of time after he was fired. And that seems to be the main case that people rely upon, and that has been relied upon for, I think I said, almost a century, as standing for the proposition that that it is constitutional for Congress to limit the circumstances under which the president can fire the head of the Federal Trade Commission, which is considered a so-called independent agency. That comports with the Constitution. Since it wasn't done that way by the president, the firing was illegal according to the Supreme Court. So why don't you tell us, I know that's not the only case, there's case prior to that called Myers versus U.S., and then you get the Humphrey's Executor, and then there are Morrison v. Olson, and then it culminates. The most recent opinion is the one involving the CFPB and a target of their enforcement efforts called Seal of Law. So why don't you take us through the precedents of the Supreme Court that bear on this theory?
Sure. So, yeah, of course, you're right. So, for purposes of these most recent firings by President Trump of members of the MSPB and the NLRB, Humphrey's Executor is sort of front and center there. But you're correct that the first real interaction with something that looks like the Unitary Executive is Myers versus the United States. This is a 1926 case. The majority opinion is written by William Howard Taft, who was the Chief Justice at the time. And Myers involved Woodrow Wilson's dismissal of a postmaster. At the time, these postmasters, pursuant to a federal statute from the 1870s, if the president wanted to fire a postmaster or remove a postmaster, he would have to go to the Senate and obtain their advice and consent. So what you have here, right, the postmasters are appointed by the president, confirmed by the Senate. He would also, if he wanted to remove that postmaster, would have to go and get the okay from the Senate. Wilson did not get the okay from the Senate in that case, and that sets up this legal challenge that consequently Myers also died during the course of litigation, but this case gets resolved by his estate. And Chief Justice Taft says that this law from the 1870s restricts the president's power to remove a postmaster is unconstitutional. And it's because, according to Chief Justice Taft, the framers intended to give the president this power to remove officers who serve within the executive branch. And generally, according to Taft, this power cannot be limited by Congress. Interestingly enough, Taft sort of carves out a little bit of an exception for the civil service, which is around by this time. And he says, this doesn't affect the civil service. We're not saying that the civil service is unconstitutional and the protections that they enjoy from firing. This just has to do with executive branch officials. And that kind of sets the case for Humphrey's Executor. This is just 9 years later, right? And Humphrey's Executor from 1935 seems to, the constitutional question seems to be fairly clear based on Myers as a precedent. But as you said, in Humphrey's Executor, the court doesn't quite, they find a way to distinguish Myers versus U.S. The FTC, which was at issue in Humphrey's Executor, is a multi-member body, right? The leadership is not a single, chair or director. There are multiple members of this board who are this bipartisan board that sort of control and serve as the leadership of the FTC. And so what the court does is they say, well, yeah, we decided Myers, which says that the president has this power to remove executive branch officials, but the FTC is different because, one, it's a multi-member body, and two, the FTC doesn't really exercise executive power. It exercises what the court says are quasi-judicial and quasi-legislative power. What they do is they, investigate and they promulgate policy, and if there's a violation of these policies, then they sort of adjudicate those violations. This doesn't really look like executive power. This looks like legislative power promulgating policy and judicial power adjudicating violations of that policy. And so Humphrey's Executor says, for bodies that are multi-member and exercise quasi-legislative and quasi-judicial power, it is okay for Congress to limit by statute the circumstances in which the president can remove that agency's leadership. Morrison versus Olson is, fast forward 53 years, this involved the constitutionality of the so-called independent counsel's provision of the Ethics in Government Act. And the court upholds the constitutionality of the independent counsel provision in Morrison versus Olson, relying quite a bit on Humphrey's Executor and the reasoning there. They say essentially, over the lone dissent of Justice Scalia, who really kind of, it's the dissenting opinion that launched 1,000 law review articles. And the court in Morrison says, well, the independent counsel certainly looks like they exercise some amount of executive power, right? They have the power to investigate and then, if necessary, prosecute violations, legal violations that occur within the executive branch. But what really matters is that, the independent counsel has a limited term. Once their investigation is completed, that sort of their office ceases to exist, and a number of other factors. And that's okay. It doesn't infringe on the president's power of removal too much. And then finally, the most relevant precedent, or not most relevant, but most recent, is the Seila Law case. And in that case, the court strikes down the statutory structure of the Consumer Financial Protection Bureau, and they say, well, under Myers, the president has a generally unlimited power to remove officials within the executive branch or who exercise executive power on behalf of the United States, and that's consistent with the original meaning of Article 2. And then they find ways to distinguish Humphrey's Executor based on the fact that the FTC and Humphrey's Executor is a multi-member body. The CFPB was led by a single director. But Seila Law really kind of signaled that the Roberts Court was prepared to go a significant distance in embracing the Unitary Executive Theory.
But they didn't, Pat, they did not overrule Humphrey's Executor, right? They distinguished it. Was there any hint in the Seila Law opinion or any concurring opinion or dissent that, that they didn't like Humphrey's Executor and thought it was outmoded because it represented a Federal Trade Commission in 1935 versus the one that exists in 2024?
Yeah, really good question. So the majority kind of steers clear of that. You are right that the majority in Seila Law distinguished Humphrey's Executor, right? On the basis of what I just mentioned. Well, Humphrey's Executor involved the FTC. The FTC was a multi-member body. We said in Humphrey's Executor that the board of the leadership of the FTC does not exercise executive power. And so we don't, under our holding today in Seila Law, it's not necessary for us to overrule Humphrey's Executor. But what the majority does do is they limit Humphrey's Executor to its facts, right? So after Seila Law, presumably, statutory removal restrictions are limited to multi-member independent agencies that do not exercise executive power. In other words, they exercise what the court said in Humphrey's is quasi-legislative and quasi-judicial power. So the court does not overrule Humphrey's Executor in Seila Law. To answer the second part of your question, there were hints, well, not even hints. Justice Thomas writes a concurring opinion. He, of course, agrees with the result that the majority reaches, but he says we should go even further, right? We should, Humphrey's Executor has been, sort of overruled in the court of history, as they like to say. It's an unworkable precedent. It doesn't sort of jive, if you will, with what we say today and what we've said in the, by then 75 years or so, or 85 years or so of intervening precedent. And we should just overrule Humphrey's Executor right now while we have the opportunity. Of course, that's just a concurring opinion. That's not the law.
Did anybody else join in that concurring opinion, as far as you know?
Yeah, it was Justice Gorsuch who joined the opinion of Justice Thomas.
So we know at least two justices on the court want to get rid of Humphrey's executor, but it doesn't, not a majority of the court. So what do you think of the reasoning in seal of law? Certainly, there is a big distinction between the CFPB and the FTC based on the fact that the CFPB is managed by a sole director. FTC is managed by a board or commission of 5 commissioners. I mean, it's clearly a distinction, but is that a distinction with a difference? I mean, it just strikes me, why is that important for purposes of determining the outcome of the issue?
Yeah, so I mean, I guess I can sort of tip my hand here and say just at the outset that I am not a believer in the unitary executive theory. I think that the historical evidence, just based on the scholarship of a number of people that I respect, challenging the historical basis for the theory is persuasive, and that the framers didn't think of the executive branch this way, that they thought of Congress as being able to have a lot of leeway in structuring not only the executive branch, but the federal government in general. So I do want to say that, and, just so that in the interest of transparency.
Yeah, and you've written, or you're in the midst of writing a law review article, right, called The Unitary Executive and Politics. Am I right?
Correct. Yes, correct. And that, for listeners who are interested, that provides the first part of that article provides what I think is a nice overview of the relevant scholarship and
on both sides of the issue.
Yes, correct. It's I try to take both sides at their best word and give them a reading in their best light. But ultimately, I think it's pretty clear that I come down on the side of opposition to the unitary executive theory. But in seal of law, the reasoning from the majority is unpersuasive to me for a handful of reasons. So one, the first reason is Roberts, the court, the majority loves to do this in these, executive power cases. They love to say that, the president is the most democratically accountable government official in the country. To a certain extent, that might be true, right? All eyes are on the president in 21st century America, right? The presidential elections are a big deal. But what do we mean by democratically accountable, right? Clearly, what the majority means is what the court means when it says this is that the president is elected by, everybody in the United States. Everybody gets to vote for president. Not everybody gets to vote for every senator or every representative or whoever else. It's only the president that we all vote for. That's certainly true, right? But there's a significant problem with the democratic accountability argument in that we have the Electoral College, right? That's an explicit check on democratic accountability. There are issues about election law, right? And these faithless electors, and once voters in a state have voted for one candidate, can those electors sort of switch and vote for the candidate who lost? I don't have expertise in that, but what I think that shows is there's some significant problems with this whole democratic accountability line of argument. The second is the second thing, and then I'll stop, is the distinction that the majority draws is clearly, I think, instrumental. It gets them to where they want to go. There's a majority of the court who believes that the president has to have this power, that the president has to be strong and has to have, the ability to control policy that comes out of the executive branch. And so I think that it wouldn't surprise me if it was Roberts behind, this negotiation about whether to overrule Humphrey's executor. They just, Roberts, I could imagine telling the members of the majority, we don't need to overrule Humphrey's executor right now. We might want to overrule Humphrey's executor, but there will be another opportunity down the line. And it appears that that's correct. That's speculation on my part. We don't know what the justices said in conference on this case, but I could very easily imagine that's sort of the consensus they reached with Humphrey's executor.
Let's circle back now to the litigation involving the recent firings by Trump, where he decides himself, apparently with advice of some lawyers in the White House or DOJ, that Humphrey's executor is no longer binding precedent, even though it did not get overruled by the Supreme Court. And he's relying just on the language in the Constitution, and he's decided he can fire whoever the heck he wants. Doesn't matter if they're a Democrat or Republican, and doesn't matter if the statute provides for a bipartisan commission, as the statute governing the NLRB does, the statute governing the Federal Trade Commission does, and several other so-called independent agencies. And he does that, and the lower courts reject, say the firings are invalid, but then there's an attempt to stay the judgment of the lower courts, which I think came up on a motion for a preliminary injunction. It wasn't a summary judgment motion. I think it was a preliminary injunction. And then we get up to the Supreme Court, and Roberts grants a stay and issues an opinion. Tell us what he says there. Why did he do that in light of Humphrey's executor?
You're certainly right. This is, this 2-page order that the court issues it stays an injunction that had been issued by the DC District Court that enjoined President Trump's firing of the members of the NLRB and the MSPB. A lot of this really is, they walk through, the legal criteria for granting a stay. That it's typical, so what we would call boilerplate language for one of these opinions. What the interesting thing from this very short 2-page order is the court's very brief discussion of the implications of, maybe overruling Humphrey's executor sometime in the future on the Federal Reserve, right? One of the arguments that Wilcox and Harris, the members of the NLRB and the MSPB, made is that if the president can fire, as a constitutional matter, members of multi-member boards, and further down the line, if the court were to overrule Humphrey's executor, that would endanger the constitutionality of the Federal Reserve. And what the court says in this order is, we disagree with that argument that overruling Humphrey's executor would present a problem for the Fed. But they don't give us any legal reasoning as to why that is. All they say is, and this is a quote, "The Federal Reserve is a uniquely structured quasi-private entity that follows in the distinct historical tradition of the first and second banks of the United States," end quote. That's all that they say in response to that argument.
I'm laughing because for a number of reasons. And that is, number one, this is the emergency docket, right? It wasn't a petition for a writ of certiorari or an appeal to the Supreme Court. And they went out of their way, basically, to create dicta in this emergency setting where nothing has been fully briefed yet on the merits. But they went out of their way, I guess, scared that if they didn't, it could cause a panic of sorts that, some people would think, oh my goodness, if this, we overrule Humphrey's executor, this means that Trump could get rid of Jay Powell, the chairman of the Federal Reserve Board, even though his term is up in about a year from now, less than a year. But that would, I think, have created a panic situation on Wall Street. And I think Roberts was trying to avoid it. But I don't understand. That gets me to the second problem. What the heck the first and the second bank of the United States have to do with the Federal Reserve Board? They did not. The first and second bank of the United States perform completely different functions than the Federal Reserve Board does today. I mean, that just sort of came out of left field, and it wasn't terribly convincing. And Professor Adam Levitan at Georgetown University put something on his blog called Credit Slips, where he ripped that reasoning apart. I don't know if you had a chance to read it, but anyway, I'd like to get your reaction, Pat, to that.
Yeah, I think that this illustrates something about the court that people are going to that people disagree with me on, but it's my contention that much of in these types of big cases, whether it's separation of powers, whether it's affirmative action, any of the cases that make the front page of the New York Times, primarily what the court is doing in these big cases is making policy, right? They're making policy judgments. They're not engaged in legal argumentation as we would think about it. You and I as lawyers, what they're doing is they have a result here in the context of executive power that they think is a good idea, and that they want to ultimately make part of constitutional and administrative law. And this one-off sentence that the court gives us in this order about the Federal Reserve and how it's different and special, that's an example of a policy rationale for what they're doing. And I agree, based on what I know about the first and second banks of the United States, that, and I don't claim expertise on the first and second banks as a historical matter, but my understanding is there are some, you could draw some rough parallels between what the first and second banks of the United States did and what the Federal Reserve does today. But of course, the first and second banks of the United States are in the early republic, right? They're 1790s up until, the early to mid 19th century. First, the global economic market is very different. It's much more robust in 2025 than it was in, say, 1830. And that means that financial regulation, what the Federal Reserve does quite a bit of now, is very, very different and much more complex than what the first and second banks were doing in the early republic. To me, it is a made up distinction to try and, one, justify and sort of hint at where the court's going to go. They're just going to say, well, maybe we're going to overrule Humphrey's executor, but the Federal Reserve is special. And two, I think they're certainly taking in, practicality and sort of economic vitality into account, which a lot of them would tell you they don't do. They just interpret the Constitution and interpret the law in their best light. But, if you're worried that if we say that the Federal Reserve is unconstitutional as it's currently structured, and that might cause, global financial panic, you're worried about something else, and you're dealing with something else than just principled legal argument.
Right. So we're getting to the end of our program. And do you believe, as I do, that ultimately, when this case gets back to the Supreme Court after, it just came up on a preliminary injunction, I don't even think there had been an answer filed in the case or a summary judgment motion, that they are going to overrule Humphrey's executor, that Trump will end up being vindicated. And by the way, it may not be ultimately this Wilcox case, the one involving the NLRB, that gets up there first. It might be the FTC case, which I understand has been fully briefed in the lower court on a motion for summary judgment, not on a preliminary injunction. So that case, there might be a final merits decision that, would get to the Supreme Court first. But I think regardless of which of these cases gets up there, it's going to be overruled. The three liberal justices will vote, will vote the other way. Will vote to, not to overrule Humphrey's executor. Maybe they get one more vote from the conservative justices, but I don't see them getting a majority. You agree?
Yeah. So I think if I were a betting man, I would say that Humphrey's executor gets overruled. They've sort of laid the groundwork, and there's scholarship sort of on, the Roberts Court's approach to overruling precedent, right? What they do is they sort of narrow the holding of a precedent they don't like. They say, well, we're not overruling this case. What we're doing is we're just, as they did in Seal of Law with Humphrey's executor, we're limiting it to its facts, right? And then they sort of let that percolate and simmer for a handful of terms. And then a case comes back to them and they say, well, this case doesn't really, or this precedent doesn't really apply very much anymore. It's been a long time since we decided it. We've decided these precedents in the meantime that sort of create tension with that. And so we think that it's time to overrule that precedent. And I think that that's very much what the discussion in a hypothetical at this point, majority opinion, overruling Humphrey's executor would look like. In terms of, you mentioned sort of how the vote might break down. I think there's a pretty good chance it's a 6-3, maybe a 5-4 decision. Justice Barrett has kind of shown a little bit more hesitancy or, maybe moderation, I guess you could say, in terms of, going as far as maybe Justice Thomas or Justice Alito want to go in these types of cases. Maybe the liberals are able to pick her off and she joins their dissent, at least partially. But even that, I'm not entirely sure of. Justice Barrett's been on the court for such a short time. We're still trying to figure out, where she stands on a lot of these things. So I have very little doubt that the court overrules Humphrey's executor formally in the event that one of these cases comes back on the merits to them and makes its way onto the docket.
When that happens, does that spell the end of the so-called independent agency? Because you combine that with the executive order that Trump issued early in his term, where he basically told all the federal agencies, independent or the ones that are clearly executive agencies, that everything's got to get cleared by the White House. Any proposed rule, final rule, any major action that they're taking has got to be approved. And if that's the case, what does it mean to be an independent agency? Not much, right?
Yeah. I mean, so there's a decent amount of scholarship that suggests, whether an agency is formally independent, meaning its leadership is insulated by statute from removal, the president still has a pretty good amount of power to sort of control, quote unquote, what they do. And I find that relatively persuasive. I mean, it's certainly true that for a number of reasons, the president has a lot of power over the executive branch. But if Humphrey's executor goes, then that makes it a lot harder on Congress to create these agencies. A few things that they could do, not a few things, but one thing that they could do is they could, figure out ways to impose greater costs on a president who wants to fire members of agencies, right? So, and of course, those types of hurdles that Congress could create could come through this statute. But also, Congress, for the leaders of these agencies, many of them need to be confirmed by the Senate. And so, you could imagine a circumstance where you've got Senate controlled by the Democrats and the presidency, and the president is a Republican. And although the president might want to fire, let's say the head of the CFPB or something like that on day one of their administration, they might think twice about firing the head of the CFPB because they know that it's going to be sort of difficult to get another nomination through the Senate if it's controlled by the Democrats, and vice versa in terms of the party. So there are additional costs for a president and his advisors to consider in these types of scenarios. But legally, or as a constitutional matter, if Humphrey's executor goes, I think it gets pretty difficult for Congress to create independent agencies. The best they could do is what I just said is, to me is, impose or hold their power of confirmation sort of over a president's head.
Yeah. And it's the end of language in a lot of statutes that say that so-called independent agencies are supposed to have a bipartisan board with members of the president's party in control, but minority membership from the other party, either, if in this case it would be the Democratic Party. So now you've got a Federal Trade Commission that's being run by 3 Republicans. And the whole point of one of the really, I thought, the better aspects of the Federal Trade Commission, which I thought was a really good thing compared to having a single director at the CFPB with that much power and a member of one party. I always thought the CFPB should have been a bipartisan commission, but now, the Congress is going to do something with the CFPB, but it's not going to create a 5-member commission, which is something I thought they should have done at the beginning and should have done until all these firings occurred and the Supreme Court came down with their order, 2-page order. So I think as a matter of policy, and putting aside completely the language of the Constitution, it's just a good idea not to repose too much power in one individual who's not the president and is not an elected official. So anyway, that's just my view as a matter of policy.
Yeah, I think that there's certainly something to that, right? And the concern that you expressed is certainly, that's what, the justices who are on the pro-unitary executive side would say. That goes back to the democratic accountability concern that they talk about in all of these opinions. But, on the flip side of that, I think that too much power in any one person, whether it's the president or a single director of the CFPB, I think that that's I know you do too. I think that it's a concern to put too much power in any one person's hands. And if the president is able to, if we have an over-empowered president, that is a big concern, because not every single president is going to, shall we say, have the best interests of the country, or, have sort of the self-restraint to say, well, yes, I'm the president. Yes, I have a lot of power, but maybe this isn't something that I should do, or maybe this isn't, maybe even though I might have the power to do this, maybe there are other concerns rather than, my policy preferences or or expediency or something like that. And, the unitary executive and over-empowered president or presidency kind of lays around waiting for someone to become the president and abuse that power. I'm not naming any names, but the concern, I think, is there.
Yeah. Okay. We've come to the end of our program. And so again, I want to thank you, Pat, for joining us today and enlightening our audience on what a lot of people thought was something very abstract and in the clouds. But I think you've really been able to provide a very good description of the theory and how it is working out in practice. We're seeing it happen right now. So thank you again.
Thank you, Alan. I really appreciate you inviting me on the podcast, and I hope to talk to you again soon.
Okay. So to make sure that you don't miss any of our future episodes, please subscribe to our show on your favorite podcast platform, be it Apple Podcasts, YouTube, Spotify, or wherever you listen. And don't forget to check out our blog, consumerfinancemonitor.com, for daily insights on the consumer finance industry. And if you have any questions or suggestions for our show, please email us at podcastsingular@ballardspar.com. Stay tuned each Thursday for a new episode of our show. Thank you all for listening and have a good day.